another crime or something similar committed in that moment. So we have problems with Article 14. We also have problems with Article 16. That is a concept that is it will be totally new in Portuguese law. It will be totally is not if we think really is not different from what we have now. The only the biggest difference is that now we need a conviction for a crime, and in the future we won't need a conviction for a crime. We only need the requirements that are in Article 16.
Thank you. Would you add something about?
In Poland, I can say with confiscation, we are partially implemented it in our national system. So we have much more problem with arrows and with managing the assets and etc. Of course, we need to make some changes, small changes to implement it fully. But this is not the main issue in Poland, I think.
Thank you. Before to give eventually the floor to other people who will be online, it's my turn maybe to give you an overview of the situation under French law. I will try to. Alors. Yeah. Okay. Thank you. Thank you. So what about the implementation of the directive of 2024 and eventually safeguards in France? First of all, I would like to give you a few general points to help you understand French seizure and confiscation law. We have several texts on the subject. A central and very long text about confiscation. This is the Article 131/21 of the Criminal Code. And since 1994, a date on which our Criminal Code came into force, this text has been amended 9 times, in particular with 2 very important acts, an act of 2010 to facilitate seizure and confiscation in criminal matters, which is the act that creates the AGRASC, our National Asset Recovery Office. And the latest, it is an act of last June improving the effectiveness of measures for the seizure and confiscation of criminal assets, which among other things, considers that now the confiscation of property, of building, is equivalent to an eviction order, whereas until now, it was necessary to go through cumbersome procedural formalities to obtain the eviction of the confiscation property. But we have also a very rich case law. Full screen. We have also a very rich case law of the Constitutional Council and of the Court of Cassation, our Supreme Court. So what will change, the confiscation is therefore a very broad concept and extensive notion. What will change with the implementation of the directive? No. On the question of transposing the directive, I would like to focus on one issue, the issue of the confiscation hypothesis. In question of the forms of the confiscation, it is the question of the forms of confiscation as provided for by the directive. The first point, which does not pose a problem, is to provide for the confiscation, either wholly or in part, of instrumentalities and proceeds stemming for a criminal offense subject to a final conviction. We may also result from proceedings in absentia, and it must be possible to realize this confiscation in value. It is Article 12 of the directive. So there is no problem on this point because of the existence of our article of penal code. The second form of confiscation is the confiscation from a third party as provided for by the Article 13 under the conditions that a national court has established based on the concrete facts and circumstances of a case that the relevant third parties knew or ought to have known that the purpose of the transfer or acquisition was to avoid confiscation. That's not a problem either because of the existence of the same article as interpreted by the criminal chamber of our Supreme Court. Confiscation applies to all property of which the convicted person is the owner or subject to the rights of the owner in good faith, or which he or she has free disposal. For the criminal court, it must be interpreted as meaning that the third party, who is the legal owner of the property, is not acting in good faith when he knows that he has only apparent legal ownership. And it is a very recent decision. The third form of confiscation is extended confiscation as provided for by the Article 14. Confiscation, wholly or in part, of property belonging to a person convicted of a criminal offense, where the offense committed is liable to give rise directly or indirectly to economic benefit, and where a national court is satisfied that the property is derived from criminal conduct. French law does not, strictly speaking, refer to extended confiscation, but that doesn't really matter. Our article, and here I'm making a link with what Professor Guandi said before the break, our article provides for two forms of presumptions that allow for extended confiscation. An explicit presumption in the case of serious offenses, offense punishable by at least 5 years imprisonment, that have resulted in a profit if the convicted person cannot justify the origin of his assets, these assets may be confiscated. They are presumed to be of unlawful origin unless proven otherwise, which presupposes that the person concerned has been invited to explain the assets whose confiscation is envisaged and to justify their origin. And the same article provides for an implicit presumption where the law punishing the offense so provides confiscation may also relate to all or part of the property belonging to the convicted person of which he has free disposal. Some authors even describe this text as an irrebuttable presumption. Because where the law so provides, it is possible to carry out a general confiscation of all the convicted person's assets, whatever their origin. The fourth form of confiscation is a non-conviction based confiscation that is provided for by Article 15. It is a confiscation of property where criminal proceedings have been initiated but could not be continued, in particular because of illness, absconding, death of the suspected or accused person. Does such a form of confiscation exist in French law? Not exactly. First of all, according to recent case law, the death of the accused extinguishes the public prosecution, that's normal, which extends its effects to the confiscation penalty. It is a new decision of last May. But on the other hand, if the assets were seized, judges may refuse to return the assets. In other words, confiscation is not possible without a conviction, but the seized assets may not be returned if they are dangerous or if they constitute the instrument or direct or indirect proceeds of the offense. In this case, the judges must take care to rule on the objective characterization of the offense without imputing it to the deceased or ruling on the latter's guilt. Case law, in my opinion, has here found a sort of compromise between the prohibition laid on by the European Court of Human Rights in the name of the right of the to the presumption of innocence on finding a person guilty of an offense when the public prosecution was extinguished by his death. And we have a very famous decision in France, Lagardère contre France, 2012. So a compromise between this case law from European Court of Human Rights and the possibilities offered by European Union text for confiscation without conviction. And the fifth form of confiscation is the confiscation of unexplained wealth linked to criminal conduct as provided for by the Article 16. Confiscation of property identified in the context of an investigation in relation to a criminal offense, provided that a national court is satisfied that the identified property is derived from criminal conduct committed within the framework of a criminal organization, and that conduct is liable to give rise directly or indirectly to substantial economic benefit. For this form of confiscation, too, there is no correspondence as such in French law. But French law provides for a combination of presumptions which may be close to this scenario. Firstly, in some cases, I have just explained, confiscation applies to property that has no established link with the offense. It is first presumption. And furthermore, and secondly, the offense for which the individual has been convicted may also be based on a presumption, second presumption, the offense of failing to justify resources corresponding to one's lifestyle. It is an offense provided for by our criminal code, or the offense of presumed money laundering, also provided for by our criminal code. In these cases, in a way, this is a form of confiscation of unexplained wealth linked to criminal conduct, isn't it? By the way, Article 16 will be, in my opinion, one of the challenges in transposing the directive, and the French legislator, with a fund of confiscation, will no doubt be very quick to respond. Thank you for your attention.
So sorry, because Filippo Spezia is not able to speak because he is the Tuscany Digos. Digos is what is Digos in English? How Digos? Digos in English? Law enforcement. Vabbè, okay. Okay, so I would like only to say something about the implementation of the directive in the Italian system of law, only some very briefly. Okay, for the different models of confiscation, we have a model of extended confiscation. We have only to check if, because we have this model of extended confiscation, which is complying with the model of Article 14. We have, it is more severe because in Italy, the disproportionate value is the only elements together with the conviction on which the presumption of the legal origin is based. So also in the opinion of the Constitutional Court, the judgment 33 of 2018, this is a more severe models of extended confiscation in comparison with the models of the old directive, the new directive. We have only to check because this model of confiscation is only for a list of offenses, that all the offenses that are now included in the new directive are also included in this rule 240 bis. This is for extended confiscation. For the non-conviction based confiscation, Article 15, in Italy we have a rule, Article 578 bis of the Criminal Procedural Code, which is which allows the confiscation without conviction in the case of statute limitation and amnesty. In the only for the extended confiscation, a model of confiscation and the confiscation of the value against the offense against the public administration, but in the opinion, in the practice of the Supreme Court, is possible to apply this rule for each model of confiscation on the basis of an interpretation that, in my opinion, is an analogy malam partem, but this is the praxis because no, so in the praxis, the Supreme Court in case of a death, in some cases, when death is after the final conviction is possible. In any case, the assets are not returned. In some cases, it's possible also to apply in any case the confiscation. But in my opinion, we have to change, to modify this rule in order to include all the cases which are of this model, because this model of the new directive is more extended, only the case of okay, illness, absconding, we don't have a problem because we have the child in absentia. So with the child in absentia, we don't have any a problem for this case. For the case of death, it is better to change the rule in a better way. And in any case, in the Italian system, with this rule, is possible the confiscation without conviction when it is not possible to carry on the criminal trial, only when there is a conviction in the first instance and there is a confiscation order in the first instance. So only the Court of Appeal and the Supreme Court can carry on with the trial only in order to apply the confiscation. So the rule of 15 in the 15 there isn't this specification, no? In this case it is strange. Our rule is more guaranteistic, more no, because there is a conviction in the first instance, and there is the conviction in the confiscation order in the first instance. In my opinion, it would be better in terms of safeguards, but it is not not compliant with the new directive. So we have to think about this rule. We have in some ways to adapt better this rule to the new directive. And I have to remember that in Italy, we had some case in front of the European Court of Human Rights about this rule in the end, because for a case of confiscation as punishment, confiscation for the illegal building, which has been considered in the Sudfond case a case of a punishment, not a preventive measure, not a security measure, but a punishment against a crime. And in the in order to apply this rule, this form of confiscation without the final conviction, in the Barbara case, Italy was convicted by the European Court of Human Rights, because it is the possibility to apply a form of a punishment, confiscation punishment, without a final conviction was considered in contrary to a violation of the principle of guilt based on the Article 7, principle of legality in the European Convention, and in some way also against the principle, the presumption of innocence. But in the GM case, after Barbara case, the position of the European Court of Human Rights changed, and the European Court of Human Rights in the GM case said that, that it is in order to guarantee the fight against some crimes, it is possible to accept the idea to apply this form of a confiscation punishment also after a not final conviction, when in any case the court is convinced of the commission of the crime and of the liability of the defendant. In the opinion of the Judge Albuquerque, this is a violation of the presumption, in the opinion of many Italian authors, it is a violation of the principle of culpability, is an analogical interpretation of the concept of a conviction, because it's not a final conviction. And there are also a big debate, but in the end, this is the praxis, because in any case, in the opinion of the Constitutional Court, we have a different judgment. For example, 49 of 2015, in the opinion of the Constitutional Court, it is enough that in any case there is an ascertainment of the fact of the crime, the offense, and of the liability, even if with no final conviction. So it is enough to satisfy the Sudfondi case, because in any case there is the proof of the liability of the defendant. So there are some perplexity about this, but in any case this is about this model. For the last model, 16, the confiscation and unjustified wealth, we have I can say that we have the confiscation preventive measure. Okay, we have to use that is more extended because we apply not only separately, without not only in a residual way but separately, but it is possible maybe on the basis of the recital. we apply not only in the sector the fight against organized crime, but also against other, in general, against each crime when there is the suspect that somebody lives with the proceeds of the crime. So, in my opinion, this rule is enough, and in the practice, not in the law, it is not written in the law. In the practice, we apply the temporal delimitation, we apply that the disproportionate value is the circumstantial evidence in the practice, and the interpretation, this is important to stress, the interpretation of this element, the disproportionate value, is very guaranteistic in the opinion of the Supreme Court, because it is necessary to give the evidence of the disproportionate value of each asset, of each property, in the moment when this property was obtained by the defendant. So this is, it is not so easy. In the opinion of the Supreme Court, this proof of the disproportionate value is a proof that is a good basis, no, of the presumption of the legal origin, because as is not the disproportionate value in general of the assets, but of each property in the moment, at the moment of the acquisition of the when somebody obtained this property. In the opinion of the tribunal, I have to say that some judge or some prosecutor are not so available to give this kind of evidence. In the opinion of some prosecutor, is too much. No, it's too difficult. So it's better to give some circumstantial evidence of the legal origin in general, and not it is so specific. It is complicated, to give this evidence. We don't have the other element in the practice. The most important kind of circumstantial evidence is the lack of other justification. The lack of of elements that demonstrate the legal origin. So I don't have my computer, but in the we have a lot of decision of the case law about this circumstantial evidence, the lack of evidence of the legal origin, the proof in a negative way. So I don't think that we have to change. It is dangerous, in my opinion, this definition, confiscation of unjustified wealth, because in Italy, the French law, the French rule about the offense of unjustified enrichment, when you are not able to justify the resources, that justify your lifestyle, in Italy was declared unconstitutional. We have before a rule 708, which the unjustified possession of instrument, the unjustified possession of assets, but only by people who was convicted for crime connected with against the property. This was declared unconstitutional because it was based on a status, not on a fact. And there was an effort of the legislator to introduce another rule of unjustified possession of assets in 1992, but the Constitutional Court declared the unconstitutionality, but in that decision, the Constitutional Court affirmed that it is possible to introduce a form of extended confiscation And so the Italian legislator introduced the extended confiscation after conviction. But it is not possible to punish somebody only because he is not able to justify his lifestyle. No? I know that we have this rule also in the Convention Against Corruption. There is this rule, but in my opinion, this rule is not so compliant, no, with the principle of the rule of law, no, against presumption of innocence, the principle of offensivity, and so on, and so on. So now I check if Albuquerque is connected. Otherwise, I try to.
A break of 5 minutes before the last presentation. Okay. Okay. Thank you. 5 minutes.
Can you hear me?
Okay.
Yes.
I think it, yeah,
Yes, we can.
it works.
Perfect. Now I can hear you.
Just a moment.
Yes, Ana Maria, I can hear you. Ana Maria? Yes, I can hear you. Hi, Ana Maria, I can hear you. I can even see you. Yes.
Yes. S- uh,
Everything's fine. I can hear you and I can see you.
Just 5 minutes, 2 minutes, because public
Okay.
will. Okay. So, dear colleague Pinto de Albuquerque, the floor is yours for the last presentation.
Thank you so much
Please.
for the invitation. It's a pleasure to be with you. You can hear me well? Can you hear me?
Yes, yes.
Okay, good. Good. Thank you so much for the possibility to make this presentation. I'm sorry that I cannot join you in person. I would have been very happy to be with you, but due to my agenda was impossible to travel to Italy right now. I'm also sorry that I could not be with you in the afternoon. It was something urgent that popped up, and I really could not avoid it. I could not postpone it either. So I had to ask for the indulgence of Ana Maria and the colleagues to understand and to forgive me for this belated intervention. Having said that, I would like to um, present very briefly the two main ideas that I will put forward in this presentation. One of them is that the subject of NCB confiscation, non-conviction-based confiscation, is at the center of a discussion in the European Court of Human Rights, and the court is still hesitant in deciding upon the nature of this measure. We have case law that follows a model of civil forfeiture, as if NCB confiscation were a model of civil forfeiture, so a civil law model, which would be similar to other measures of punishment of unexplained wealth. And we have a different model, which is a criminal law model, which is closer to the guarantees provided by criminal procedure. And here we have at least four different groups of cases. Let me try to sum up this group of cases before I come to a conclusion with regard to the guarantees that the court has provided until now to people who have been subjected to non-conviction-based confiscation. So in terms of the criminal law model, what we have is basically four groups of case law where the court distinguished between confiscation orders that have been imposed within criminal procedure to third persons who are not procedural subjects, for instance, are not the defendant in the procedure, nor anyone associated with the defendant. And here we can find several cases that the court has mentioned in this regard, like GM, like Telbiz versus Romania, like Rumi versus Estonia, or all the cases regarding Eastern European countries, Lithuania, Estonia, and also cases regarding Italy, not only GM, Sudfondi, and other cases, similar cases. We have a second group of cases which relates to confiscation orders delivered within criminal procedure that are imposed on the defendant, but in the case of acquittal of the defendant or discharge for any procedural reason. For instance, when the time has passed, the procedure is no longer admissible for because it has become time barred. So in this type of cases, you find Balsamo versus San Marino, you find Goerings versus the Netherlands, you find Saliba versus Malta, or Raimondo versus Italy. All of these cases refer to this second group of non-conviction based confiscation. The third group of non-conviction based confiscation has addressed confiscation orders delivered in a administrative or civil procedure, so non-criminal procedure, who have been imposed on people suspected of having committed a crime. So people who have been under the suspicion of being authors of a crime and have been subjected to confiscation orders within a non-criminal, non-penal procedure. Here you have Walsh versus United Kingdom, Webb versus United Kingdom, Butler versus United Kingdom, and all cases coming from the British jurisdiction. The fourth type of cases is confiscation orders delivered in a non-criminal procedure, so administrative or civil, that have been imposed on third parties who are somehow connected to a person suspected of a crime, of having been having committed a crime. And here you have Gogitsi versus and others versus Georgia. You have Cacucci and Sabatelli versus Italy, Bongiorno and others versus Italy, Perre and others versus Italy, and many other Italian cases. This can also happen when there is acquittal or a discharge of the person suspected of being authors or connected to the person's authors of a crime. So different types of cases where the court applies different set of guarantees. This is extremely important because the court substantively admits that all these measures have to comply with the principle of legality and the principle of proportionality. All of these measures are under these two principles, not due to Article 7, but due to Article 1, Protocol 1. So Article 1, Protocol 1 is the source, is the ground for the applicability of the principle of legality and the principle of proportionality. Another principle that derives from Article 1, Protocol 1, which is applicable across all forms of NCB confiscation, is judicial oversight. So even in the cases where these measures have been applied by administrative authorities, there should be a legal avenue to a court of law where judicial oversight is guaranteed. Now, the problem is more complex with regard to the requirement of a finding of of guilt? Is there a requirement of a formal finding of guilt? The court says that there's no such requirement, and accepts that there can be forms of NCB confiscation without any formal finding of guilt with regard to any other of the participants in the criminal procedure, or to persons attached to the persons or connected to the persons involved in the criminal procedure. In some cases, the court has admitted that there should be a guarantee of the presumption of innocence, and therefore there should not be a reverse of the burden of proof, which means that the burden of proof should remain on the public prosecution, and the criminal standards of conviction should remain conviction on the basis of solid evidence beyond reasonable doubt. This is an exception. The case law normally does not require such guarantees of presumption of innocence and the requirement of the criterion for conviction based on evidence beyond any reasonable doubt. This is the exception, but it's important that we refer also to these cases where such requirements have been imposed by the court, because it shows that the court is still hesitant with regard to the nature of such measure. In these particular cases, these exceptional cases, the court went on to demand also and to require the compliance with the guarantees from Article 6.3, not only 6.2, but also 6.3. And here, of course, the most important one is the fact that the guarantees should be applicable to the person who is subject to this measure, as if it were a defendant in a criminal procedure, as if it could be a defendant in a criminal procedure. All the guarantees, including, of course, the possibility to present evidence against the prosecution, the right to legal assistance, the right to free translation, free interpretation, the information regarding the elements of the accusation. All these guarantees would be applicable as if the person would be a truly defendant in a criminal procedure. Again, this is not the rule. This is the exception. The trend is that the court gives up these guarantees in regard to NCB confiscation. This is the exception. But the fact that there is such an exception shows that the court is not clear about the nature, is still not clear about the nature of this measure. What is decisive for the court, and this is really what I would like to underline, is that the fact that when there is an element of bad faith, or when there is a punitive purpose attached to the confiscation measure, then the court has no doubt and considers that this measure should indeed be considered as a criminal law measure under the guarantees of 6.2 and 6.3. So the important thing for the court is to check whether there is an element of bad faith in the conduct of the person who has been subjected to this measure, or when there is a punitive purpose on the part of the judicial authority that can be derived from, for instance, from the motivation of the condemnation. In either of these cases, the court considers that ultimately the purpose and the bad faith element transform this measure into a measure of criminal law, which should should be dealt with under the guarantees of Article 6, 2, and 3. Of course, 6.1 plus 6, 2, and 3. If that is the case, then the court also admits the applicability of Article 7, namely the principle of legality deriving directly from Article 7 and not from Article 1, Protocol 1. When the court considers that the measure has a criminal law nature, then the court bases the principle of legality not in Article 1, Protocol 1, but directly in Article 7. In this type of cases, the court does not enter into the discussion of Article 1, Protocol 1, and considers as sufficient to discuss the matter under Article 7. So, to sum up very briefly, the issue here is to determine the nature of the measure in light of the purpose of the measure according to the motivation of the decision, first, and second, the element of bad faith that may be evidenced in the conduct of the person who has been subject to this measure. When there is such an element of bad faith, or when there is a punitive purpose on the part of the judicial authority, then the guarantees of Article 6, 2, and 3 should apply fully. And this in line with the nature of such measure as a criminal law measure. When there is no such element of bad faith, or there is no punitive purpose, when there is no element from which the court can derive this, the European court can derive this punitive purpose or this element of bad faith, then the court is tempted to accept this measure as a civil law measure inspired in the civil forfeiture measure, and subjecting this measure only to the guarantees of Article 1, Protocol 1, namely principle of legality, proportionality, judicial oversight, and 6.1. Not 6.2 and 3, but only 6.1. 6.1, which means independent oversight, impartial oversight, equality of arms, in order to have a fair trial. In this regard, we have interpretation of the equality of arms requirement that, in fact, is very close to what the court requires from a criminal procedure. When the court under Article 6.1 requires that in order to be fair, there should be an equality of arms, the court interprets 6.1 in the light of the guarantees of 6.3. And that makes it almost impossible to distinguish this guarantee from a classical, traditional guarantee of criminal procedure. So the puzzle gets complicated in this set of circumstances, and that's why I wrote in Varvara versus Italy that the case law needs clarification. The case law is not clear at all. It needs clarification. GM at the level of the Grand Chamber does not provide for that clarification, still complicates further the situation. The picture is not clear, and this is bad for the legal authorities at the national level, because they do not get guidance from the European Court in regard to the guarantees that they should provide at national level. When the court has case law that is not clear, this makes the life of public prosecutors at the national level more complicated, because they do not know what to expect from Strasbourg. And this is, of course, not good for criminal prosecution, and also for the side of the defense, because the defense does not know what type of guarantees it can expect from the Strasbourg court, whether the full application of guarantees of 6.2 and 6.3 will apply or not. So in part, the fault of the situation is, of course, the court's fault, because it has not provided clear enough case law which should serve as a sufficient guide for the public prosecution at national level. I can expect that the Court of Justice can deliver such guidance because under the new directive, such guidance should also be inspiring the new implementation the implementation of the new standard of the European Union, and of course the ultimate voice in order to guarantee that this guarantee this set of rules in compliance, in full compliance with the Charter of Fundamental Rights and ultimately with the European Convention is the Court of Justice. So we can expect that the Court of Justice will provide the guidance that the European Court of Human Rights has not provided until now. That is what experts have expected. That is what the court also promised in discussing measures in several cases that are similar to confiscation. And if this promise is kept, if the court really enters into this debate, we can expect that the court in Luxembourg will provide the guidance from this set of rules, this new set of rules, and the correct interpretation that the Charter and the Convention will require of this set of rules. This will put, of course, the European Court of Human Rights under pressure in order to provide at least the same type of guidance, the same type of case law. We know that there is a dialogue between the two courts. This has happened in the past. And in this case, we expect that the Court of Justice will push forward an agenda that will help the court in Strasbourg to review its own case law. It has done much of the case law which has been delivered has not done really what we could expect that it could have done, which would be to provide this clear guidance in order to make clear what to expect. It's also a circumstance that derives from the fact that the legal framework is still very different from country to country, and the court is confronted with norms that are not really comparable, which makes judicial assistance, international judicial cooperation extremely difficult because forms of NCB confiscation may have a different label in different countries. So the court is also confronted with this additional difficulty, which is different legal language makes it different, makes it extremely difficult for the court to set the same guarantees, the same set of guarantees in different legal frameworks, and therefore the uniformization that we expect from the European Union will help in that regard, because we'll provide the background against which the same set of guarantees can be applied and can be interpreted by the Court of Justice, which will then inspire, we hope, a reform of the case law of the European Court of Human Rights. So I think basically the court has still a long way to go to provide the clearance that we need, has done so with limitations, as treated differently for different types of cases, which has not helped much in terms of the consistency of the case law. This is the main critique that can be addressed to the European Court of Human Rights. And of course, this begs the question: when will that be provided? When the court will provide such new case law? It has an opportunity when the implementation of this new directive within the European country bound by the directive will start, will bring new cases before the courts, and these are brought before international instances, be it the Constitutional Court at the national level and the international level, the Court of Justice and the European Court of Human Rights. Then we can expect that a certain pattern of case law will develop that is more consistent and coherent, and will clarify ultimately what we can apply in terms of the guarantees. The picture right now is mixed, is confused and confusing, and as I said, public prosecutors have a very difficult task to anticipate what the court will decide in each individual case. The same is valid for the defense. We never know. It also depends on precedent. It also depends on the way the cases have been dealt. Similar cases have been dealt with in Strasbourg, in the same jurisdiction, and that is the most that we can say. Precedent is still kept, is still respected, but more than that, if the case brought before the court has some new feature, some factual new feature that is different from the previous cases, that may entirely change the result of the case, and the output may be surprising the court, implying that due to that specific feature, the court no longer follows the precedent and applies a different set of guarantees. That has happened in the past, for the surprise, of course, of the respondent states in that cases. But the fact is that the court, for reasons that sometimes are not very convincing, considers that some specific facts justify departure from precedent, which in fact makes it quite unpredictable, the result of the case law. Makes the output quite unpredictable in terms of the guarantees applicable under Article 6 and 7. What can be said right now is that Article 1, Protocol 1 is the minimum of guarantees that are considered as applicable to any form of NCB confiscation. This is the minimum of guarantees. Article 1, Protocol 1, namely, and to come to an end, legality, proportionality, and judicial oversight. But of course, this is not enough, and the discussion is on the additional guarantees that can derive from 6 and 7. Thank you so much for your patience and for your indulgence and understanding. And again, thank you for the invitation. I'm at your disposal for any queries, any additional questions, not only by writing, but also here in presence. Of course, you have my contacts, you have my email. Ana Maria can provide you with my contacts if you do not have them already. And I'm always available for any queries by writing, but also here in the time that still is available for any queries that you may have. Thank you.
Thank you for this very interesting presentation online, and for stressing all the issues related to the nature of the measure and the resulting risks of this. So I don't know if there is some questions of if Anna Maria will add something before closing the session.
Paolo?
Yes, I can hear you
Yes,
perfectly.
yes.
Anna Maria.
Have you some opinion about Cavallotti case? I suppose that you know this case in front of European Court of Human Rights. The case is the possibility to apply confiscation against somebody who has been acquitted in a criminal trial. In this case, is an entrepreneur, businessman, business family who in Italy there was the application of a preventive confiscation against the whole asset and the entire property of his defendant, but after an acquittal in the criminal trial. So there is this case about this possibility. I don't know if you have read something about this
Yes,
case.
well,
You have an opinion.
this is a typical case of confisca senza condanna. So will probably be dealt with by the as the court has done in previous cases of such nature. The court will probably deal with it under the second group of cases. So when there is an acquittal or discharge, and we'll probably deal with it like it did in Balsamo, Goerings, Saliba, this type of cases. So I would say that this case is similar to that type of cases, and if it is so, then the court will consider the case only under Article 1, Protocol 1. That is probably what is in line with previous case law.
Thank you. Other question? Oh. Thank you. Thank you for the session, and see you tomorrow, I think, at 9. Yeah. See you for people online.
Thank you so much for the invitation again, and my apologies for not being with you